Someone make it make sense.
Probably a couple.
Hello, hello. How are y'all doing? We've got snow, we've got ice here. I hope everybody is safe. Those of you guys, especially our squirrel friends who are in California, hope you guys are safe as well with the fires going on and everything. Shout out to Flash. And Flash, by the way, is having great success with his Discord, where he is streaming right now the OG suitcase trial through Discord, which is awesome. And also glad that we've got some squirrel friends too who've been joining for that. So yeah, so we are back though with coverage here with Shanna Gardner. So we have covered, we had part one already of these death penalty motions. So we are picking up where we left off. And again, I double checked the dockets just this morning, and still for Mario, her co-defendant, there's not been anything else filed for his motions regarding the death penalty apart from the exact same, some of the exact same ones that we have here for Shanna, although she's got additional ones. In total, there's been 14 motions filed by her defense team regarding the death penalty, which is one more than we had for Brian Kohberger. They had 13. So we are going to pick up right here. So this is just from November 15th, 2024. So recently. All right. And one thing that's interesting is, you know, again, with having covered all the death penalty motions for Brian Kohberger, you know, as it pertains to the victim impact evidence, they had a lot going on regarding motions to trifurcate. And of course, all of that was denied, but it'll be interesting to see what they say here. Also noteworthy, of course, is that in Florida, the legislation changed in 2023, I believe, to where they only need 8 out of 12 jurors to vote for the death penalty versus being it unanimous or versus 10 out of 12, which is what it used to be. And we will see motions as well regarding that coming up too for Shanna Gardner. But right now we're dealing with this victim impact evidence. So, okay. So Shanna Gardner moves this honorable court to enter an order precluding victim impact evidence because substantial, new, and powerful empirical evidence demonstrates that it is so unduly prejudicial as to violate the 14th Amendment to the U.S. Constitution. There's a footnote. In making this motion, the defendant is aware of and acknowledges the existence of precedent that has held that Florida's use of victim impact evidence is constitutional. The defendant contends that new data stemming from studies conducted since these cases demonstrates that the use of victim impact statements during a capital penalty phase supports a departure from this precedent. So, you know, again, we know that courts have to follow, you know, they're going to follow the precedent, right? But this is important because, you know, when do we get new case law? Well, when we've got a novel case, right? We've got a case of first impression. But we could also see things. We could see courts departing from that when, for example, you've got new data, like is suggested here, right? New data, because we've got new information. Maybe now, like in other words, there has not been an opportunity since the new data, right, for courts in Florida to depart from the precedent, but due to incorporating that new information, right? So, okay. Moreover, new evidence demonstrates that victim impact evidence violates the 8th Amendment, specifically under Florida's capital sentencing scheme, which does not permit evidence of non-statutory aggravating factors to be presented. And again, we've mentioned this with the BK coverage as well, right? The statutory aggravating factors, we've talked about those. In both Idaho and Florida, the burden for the sentencing phase is upon the state to prove to the jury at least one of those statutory aggravating factors beyond a reasonable doubt. So non-statutory aggravating factors, what is that? That's victim impact evidence. Finally, it is now clear that victim impact evidence violates section blah, blah, Florida statutes because its probative value is substantially outweighed by the danger of unfair prejudice. So that sounds a lot like a 403 or 404 argument, doesn't it? Confusion of the issues, misleading the jury, or needless presentation of cumulative evidence. And both of these were mentioned as well in the BK motions, confusion of the issues and misleading the jury. Okay, so memorandum of law and empirical data. So we're going to maybe learn some of this new data that was just referenced. In 1987, the U.S. Supreme Court held that the admissibility of victim impact statements violated the Eighth Amendment because this information is irrelevant to a capital sentencing decision. I couldn't agree more. And, you know, I've talked about this before, but, you know, for any of you guys who haven't followed all of the BK coverage, right, you know, the thing is that victim impact statements are important, and it's an extremely important part of this judicial process, right? That the victims are able to be heard, and you know, discuss how this loss has impacted their lives, right? And many other things. But you can see where it's unfairly prejudicial in a number of ways. One, because the extent to which somebody experiences grief is a personal thing and will vary by the person, right? The victim's family member that is experiencing it. For example, you know, sometimes you have victims' families that speak out and talk about how, you know, they have, well, for example, there's been some cases that I've watched or trials that I've watched where there's surviving victims for, sorry, still getting over being sick. Where there's like, for example, like there's been a couple like mass shootings or school shootings maybe. Or like there's that shooting that happened at the Waffle House, whatever, a number of years back, where like there's people that survived, and not that they need to be doing this, right? But like they have, and during their victim impact statements, for example, they talked about how in a way, I'm paraphrasing, but this was the best thing that ever happened to them in a way. Like it made them change what they were doing in life, or it made them look at things differently or whatever, right? And it's really powerful when you have a victim impact statement and the victim speaks to how they feel empowered, right? But you know, if you go by that, then it's like, well, then, you know, if we're supposed to be punishing somebody based on the extent to which a victim is negatively influenced, that doesn't make any sense, right? But again, to the same end, that's a spectrum, and victims should be allowed to feel either more empowered if they survived, or if they're a surviving family member, they should be able to feel, you know, whatever they feel in reaction to this as being a victim or victim's family member. That is a personal thing. And so there's that, first of all, right? But you can see also how people getting really emotional on the stand, you know, as victims, family members, can influence a jury. And I've spoken about this before as well, where like people that like take cold cases, for example, right? Or take people who maybe are killed in a heinous crime, but just don't have that many surviving family members, or family members that don't want to make a statement. And it's not fair to them that their case is taken less seriously, or the sentence is taken is decided differently by a jury just because they don't have that opportunity with people to come and speak on their behalf. So I've always said that it makes so much more sense to me for the sentence to be based on the statutory aggravating factors, right? And then once and whether it's a death penalty case or not, right? That you have, once you have the sentence rendered and handed down by a judge, then you can have the victims come in, and therefore it's not affecting anything. And the other thing is, it's in a lot of ways better for the victims because there are restrictions placed on the victims when due process is still a factor. And when is that? That's before the sentence, right? So, for example, in the Ezra McCandless trial, we saw numerous objections during the victim impact statements. And there has been a couple other trials recently where there were also objections made during the victim impact statements. So, in other words, there's limitations on what they can and can't say. And so if you imagine, if it's after a sentence, right, then the victims don't have to worry about that anyway. So that's just, in summary, some of the reasons why I think it's a good idea for the victim impact statements to happen after a sentence. So shout out to Excited Utterance. I know this is your first time here, but we've chatted before in Andrea Burkhart's chat. So happy to see you. Welcome to the Scroll Crew. I don't know when the next hearing is, and it's not been posted on the docket either. As far as like the scheduling order, the most recent hearing was on the 6th, but it was like 4 minutes or something, and like nothing really happened. So I don't know when the next hearing is, but I'm so happy that you're here joining us. And feel free to join the Discord as well, and become a part of the Scroll Crew. Right. Yeah. So stop. So Flash saying why they're trying to stop it. Are you referencing the limiting the victim impacts, like what they're allowed to testify to or speak about during sentencing? One good example, again, referencing the Ezra McCandless trial, is that one of the friends of the victim and friends of the former friends of the defendant, and who's been convicted in this case, right, was speaking to the defendant. And we always see that, right? In most cases, when you have a victim impact statement, they're speaking to the defendant. And by that, I mean, you, because of your actions or your decisions, right? Just like that, right? Not anything crazy. Sometimes it is crazy. But in this case, with Ezra's trial, it was very respectful, and it wasn't name calling. It wasn't, it wasn't you're a monster or anything like that. But it was just saying to you, Ezra, right? And that was one of the things that lodged an objection from the defense, saying they have to address the court and not the defendant. That's just one example. And so they had their statement right now, and they had to, on the fly, in their mind, while they're giving that impact statement, change who they're speaking to on the fly from this. Yeah. So yeah, just one example. And again, because of the fact that if the sentence hasn't been decided yet, due process is still at issue. And so therefore that's why that can happen. Of course, there's plenty of times where we don't see objections, but they're able to do it, and it has happened. So, okay. So again, the U.S. Constitution found that the information is irrelevant to a capital sentencing decision. A capital is an emphasis added here. The court found that its admission creates a constitutionally unacceptable risk that the jury may impose the death penalty in an arbitrary and capricious manner in that one. Since the focus of victim impact evidence is not on the defendant, but on the character and reputation of the victim and the effect of literally what I was just saying, right? The character and reputation of the victim and the effect on the victim's family. And again, this can vary, right? Factors which may be wholly unrelated to the blameworthiness of the particular defendant. Absolutely agree. Allowing the jury to rely on a victim impact statement therefore could result in imposing the death sentence because of factors about which the defendant was unaware and that were irrelevant to the decision to kill. This evidence thus could divert the jury's attention away from the defendant's background and record and the circumstances of the crime. Oh, by the way, Excited Utterance, question for you. When is Andrea going to have another stream? I was just checking, and it's been like a month or so, and I hope she's okay. I know sometimes she likes to take time, especially after Delphi, which is understandable. But I just didn't know if you had any idea when we would be hearing from her again, because I miss her streams. Okay, so we also have a quote here from the case law. It would be difficult, if not impossible, to provide a fair opportunity to rebut such evidence without shifting the focus of the sentencing hearing away from the defendant. And 3, the formal presentation by the state of information in the victim impact evidence can serve no other purpose than to inflame the jury and divert it from deciding the case on the relevant evidence concerning the crime and the defendant, the admission of the victim evidence being inconsistent with the reasoned decision-making required in capital cases. The court went on to say, while the full range of foreseeable circumstances of a defendant's actions may be relevant in other criminal and civil contexts, we cannot agree that it is relevant in the unique circumstance of a capital sentencing hearing. For years after Booth, the United States Supreme Court reversed itself in Payne v. Tennessee, another U.S. Supreme Court case there from 1991. The court ruled in a 5-4 opinion that victim impact evidence was not a per se violation of the Eighth Amendment. Interesting. So Justice O'Connor here stated, we do not hold today that victim impact evidence must be admitted or even that it should be admitted. We hold merely that if a state decides to permit consideration of this evidence, the Eighth Amendment erects no per se bar. Unfortunately, the court provided little guidance to the states on the parameters of victim impact evidence, other than noting that if in a particular case, a witness's testimony or a prosecutor's remarks so infects the sentencing proceeding as to render it fundamentally unfair, the defendant may seek appropriate relief. There it is, due process, right? What was I just saying? Due process clause of the 14th Amendment. Yep. Again, why is due process still a factor here? Because the sentence hasn't been rendered yet. Oh, wow. Okay. Well, I plan on streaming that. And according to the scheduling order, it looks like it's actually going to be 2 days, which I don't know that anyone's noticed, but yeah, not the scheduling order, on the subpoena. The subpoena calls for the 23rd and the 24th all day. So it looks like it's going to be 2 days, which isn't surprising. So I'm going to stream that. I may be doing it live, or it'll be like that same night or whatever. But yeah, I am really geared up for that 100%. Definitely everybody needs a break. Oh, she's on holiday. That's good to hear. I'm glad she's taking a holiday. That's good. So that's good. Although I do miss her, but glad she's taking a break. So the court has largely remained silent on victim impact evidence since Payne. Oh, speaking of Kohberger, by the way, I will be having another stream tomorrow on that, because we've got some more to follow up on from the most recent court filings. And also, we should see, hopefully by tomorrow, because it was due on the 9th and it just hasn't posted yet, the witness list, the defense witness list for these upcoming motions to suppress hearings. And so, because the subpoenas, of course, were blank, they were redacted. So in other words, we will find out when we get that witness list who is coming to speak to the court and us viewing. And I have some thoughts on who that will be. But tomorrow I'm going to cover whatever else comes out. And then also, I've been working really hard on a presentation regarding the timeline of the white Elantra and the DNA and what's missing from the timeline. And I've got a number of things that I wanted to go over a couple days ago, but my voice was failing me because I've been getting over laryngitis. And so I didn't get to do it. So we're going to do that tomorrow as well. And I'm really excited for that too. So, yeah. And I mean, the thing is that, well, the other thing about the Franks hearing too, the judge has not actually, he's not ruled on that yet. Right. Because again, it was still a motion. It was a motion for a Franks hearing, and his response that he allowed them to clarify their page numbers, if you guys recall that, signaled to me that he was going to grant that motion, but it has not come out yet on the docket. So, and I have every reason to think that that's going to be, of course, sealed, closed to the public, unfortunately. But yeah, I do believe that will be granted. That's going to be crazy too. So, okay. So Justice Stevens and Justice Breyer wrote statements regarding the denial of petitions for writs of certiorari in 2 cases where victim impact evidence was presented during capital sentencing proceedings. Both justices were critical of the failure of the court post-Payne, funny, Payne, right? Speaking of BK, to provide any guidance or clear limits on the scope, quantity, or kind of victim impact evidence capital juries can consider, and recognize the strong emotional and prejudicial effect of victim impact evidence on a capital jury. At the time of Booth and Payne, there were no empirical studies as to what victim impact evidence. Again, this is what they're saying is different now. We've got studies done, right? Empirical studies as to what effect victim impact evidence had on a jury deciding whether to impose a death sentence or a sentence to death. The court relied on legal arguments for and against the admissibility of victim impact evidence. Since Payne, studies have confirmed that the fear that victim impact evidence infects sentencing proceedings, rendering them fundamentally unfair. Jurors who hear victim impact evidence are far more likely to render a verdict based on emotion than the characteristics of the defendant and the circumstances of the crime. Right there. Very well said. The most comprehensive and accurate study was published in 2013. And it's interesting because, I don't know why they didn't cite any of this new information in the BK filings. But they didn't. So, of course, this would be considered, a non-authoritative source, right? Because this is from a law journal. So it would be like they can consider it, but it's not authoritative, right? But still, it's persuasive, right? But you can still, I'm surprised they still didn't use it for BK's filings. They selected participants. Oh, wait. No, just kidding. Okay. So this study that's being referenced here, they did talk about the study. They just didn't cite this journal, but this study did come up. You guys will recognize this because we covered this. Okay. They selected participants from the actual jury list in a mid-Atlantic state and then, quote, death penalty qualified, and quoted them. The results of the study revealed that when jurors were exposed to even a relatively low dose of victim impact evidence, its effect caused substantial bias toward the victim and the victim's family, as well as prejudice against the accused, where such bias and prejudice was sufficient to deny due process. And actually, I believe that one of their experts that they are going to bring in or want to bring in for the sentencing phase was one of the researchers who actually conducted this study. The Quick Glimpse study is one of the most detailed and well-designed studies on the effects of victim impact evidence. Furthermore, the study is the most recent in a long line of research that demonstrates empirically that victim impact evidence introduces inconsistencies, bias, and prejudice into trials. Past empirical studies have also shown that victim impact evidence is unfairly prejudicial. In a study conducted in 1995, researchers used a group of college students and told them that they were to decide the sentence of a defendant convicted in a capital crime. They proceeded by reading identical written summaries of the prosecution and defense arguments for the penalty, but only one group was provided with victim impact evidence. The study discovered a substantial effect for victim impact evidence. When it was present, 51% of the subjects voted for death, but only 20% of the time when it was absent. So we got some more studies here. Flash is saying that you had too long of a trial. Yeah, I'm excited for it. It's funny because also my personality, right? Like I'm a long distance runner, right? Like marathon, like 5K. I don't understand a 5K. I don't understand a half marathon, right? Like I like the long form everything. So I'm totally the only challenge is going to be covering that, but also Shanna Gardner, assuming those dates stay the same, right? For everybody, they're going to overlap. And I think there's another trial that might potentially overlap as well, but I can't recall. By the way, have you guys heard of the Rose? What is it called? They're calling it the Rose Petal murder. I meant to mention this the other day and I forgot. Have you guys heard of that? Because it starts tomorrow and this is in South Carolina. And it's not been highly covered, but Fitz News has been on that case, of course, from the get-go. And it's unfortunate because they have everything behind a paywall. But what's really crazy about that case is that the defendant is a classically trained concert pianist who went to Juilliard. So talk about my worlds colliding, right? Because being a classically trained violinist, I was like, what? Like this dude, okay, memorized and performed on, and it's apparently on YouTube, every single Beethoven piano sonata for memory in order, like back to back to back. And like something like 13 days later was charged with murder. Gardner won't go to trial. Yeah, so it'll be interesting to see because one of the things that is really interesting that came out in the second bond hearing was the timeline of the checks. Did you guys see that? Where, in other words, the confession, quote unquote, from Henry Tenon, where it was giving the timeline of being paid or whatever. And it was already weird enough that it was supposed to be like getting paid after the fact or whatever, but there was like a down payment or whatever. But all those checks, right? The prosecution had represented them as being from the year of the homicide, from the months surrounding it, right? And it was from the year prior. Like in my like the money trail is gone now, right? Like they don't, like that's insane. So I don't know. I mean, I don't know how you prove any of it if you don't have that, really. I mean, in other words, what that points to me is almost like a false confession, right? Because he told them that the checks were for the murder at that time, and they were from the previous year. Pretty insane. So there's a different number of options too, right? Like it could be something like, maybe some of these death penalty motions, right? But think about, like, for example, like with Lori Vallow, her trial in Idaho, right? The prosecution in this case, Shanna Gardner, right, has, to quote Judge Newman, they've been flying close to the sun, hoping they're not going to get burned, dance through fire and hope you're not going to get burned, that type of thing. And it's not out of the realm of possibility that they do something else, right? And it could be a sanction to the prosecution, right? That, like what happened with Lori Vallow, discovery violation, right? That then the death penalty is taken off the table. So that's a possibility. There's also a possibility that something happens with these motions, because we're going to get to the motions regarding the change in the Florida statute from 2023. So, there's a number of things that could happen before October comes around. Yeah. So, okay. So let's see here. So we're going to skip through some of this here. Right. By changing their focus from the plight of the defendant to the victim, the jury's sentencing decision would be based not upon a rational and reasoned consideration of the background and characteristics of the offender and the circumstances of the crime, but on the emotions they feel after viewing the victim impact evidence. Okay, so let's see what else. I think we probably got some. Okay, argument. Here we go. All right. Victim impact evidence violates the due process clause of the 14th Amendment. So this is from the U.S. Supreme Court here. The court, without the benefit of any empirical data, key factor here, without the benefit of any empirical data, right? Because what they're saying now we do have that benefit. So without that benefit, regarding the specific impact of victim impact evidence on jurors, noted that such evidence can be so unduly prejudicial that it renders the trial fundamentally unfair. This holding is consistent with the law in Florida. During a penalty phase, there's fundamental error and a denial of due process if evidence is admitted that is so prejudicial as to taint the jury's recommended sentence. Evidence is unduly prejudicial, all right, when it appeals to a juror's sympathy, arouses its sense of horror, provokes its instinct to punish, or otherwise causes a juror to base his or her decision on something other than legally permissible basis. To that end, let me just say this, guys. Even when you look at this, okay, even the statutory aggravating factors in Florida, right? The ones I hate the most, the hack, right? Heinous, atrocious, and cruel. The utter disregard for human life. And then in Florida, you've also got the, CCP, cold, calculated, and premeditated. But like, take the first one, the hack, which I hate more than all of them. Heinous, atrocious, and cruel. That's a statutory aggravator. I mean, already you can see how there's in my mind, a problem, right? Because, appealing to emotion, right? Like, look at this, arousing the sense of horror. And there's a big difference between something like the hack aggravator versus like multiple victims, or having, or like, for example, depending on the state, right? Maybe if the murder was of a law enforcement officer, or, or like take, for example, New York State, in order to be, for a capital murder there, one of the factors would be akin to a serial killer. Like you have had to have killed like at least 3 people over a certain period of time. Like, so, in other words, things that are like, things that are objective, Like, yes, more than one person died. Yes, this was a law enforcement officer. Is completely different than like the hack aggravator, right? Or the utter disregard. So anyway, just noting that because those are still statutory aggravating factors. So, right. So Flash saying no matter how dirty prosecution may be, you really shouldn't limit victim impact statements. It's not fair. So remember, not fair to who? Because remember, if it's before the sentencing, if it's before the sentence has been rendered, right? The fairness that matters is fairness to the defendant because of due process. That's the fairness that matters. And then here's where it's unfair to both sides, right? Because of due process and having to be fair for the defendant, right? Then you have to limit the victim impact statements, which is unfair to the victims. However, right? If they were to give this is my solution to this, but this is not, and this has not been in any of the motions. This is just my solution personally, right? If the victim impact evidence and the victim, if those statements are made after the sentence is given, then it's fair for everybody because there's no limitations. You see what I mean? Due process is not a factor there. The sentence has already been handed down. And because you don't have to worry about fairness to the defendant, then therefore, there's no limitations that would be unfair to the victims, if that makes sense. Oh yeah, definitely. And we covered all that. It was crazy. I almost fell over when what's her face? Sue, what was her last name? The friend, Shanna's friend came in for that bond hearing. I was like, oh my God. And the way that, it was that was insane. And just her explaining how they completely misstated her testimony for the grand jury, and then the way she contacted the defense. And there was a lot of weirdness there, like the way that the detectives like showed up at her house and was like threatening her. There was and the way they like kidnapped her from the parking lot of the grocery store. There was a lot. But I covered that, and we talked about that at length, like the nature of like her interrogation, right, and calling her an unindicted co-conspirator. They're still calling her that. They still call her an unindicted co-conspirator. It's crazy. It's crazy. It's very crazy. All that. Yeah, Kim Jensen. Thank you. Why did I say Sue? Thank you, Kim Jensen. Yeah, Kim Jensen. And like, like basically what they had that, and then they were supposed to have a money trail, but the money trail is shot to shit. I mean, it's the wrong year. So, which is really funny because like YouTube recommended a video from just yesterday, right? And it was from, the local news outlet there in Jacksonville. And it's like the title is like money trail shows new evidence and blah, blah, blah. And I'm like, oh, did something else happen with this that I missed? How did I miss it? Right. And I click on it and it's literally showing the images from the bond hearing of those checks. But what they don't even explain is they don't even explain what you're looking at. And they also don't explain that it's the wrong year. So it's just like, oh, this is just so dumb. It's misinformation, y'all. Frustrates me. Okay. It is clear that jurors who receive victim impact evidence are more likely to base a decision to sentence a defendant to death on emotion, sympathy, hatred, hostility, vengeance, anger, etc., instead of a reasoned weighing of aggravating factors and mitigating circumstances as required by Florida's capital sentencing scheme. Emotion is an illegal basis on which to oppose a death sentence. Funny, the case law here is Gardner. There cannot be a fair trial when emotional evidence unrelated to the actual crime is a major factor in a jury's choosing to impose a death sentence. Victim impact evidence, and it's freely, that's got to be a typo because that's not a word, and powerful emotional effect of causing sympathy for the victim and the victim's family, and anger and hatred towards the defendant is so unduly prejudicial that violates there it is again, due process, right? 14th Amendment. Yep. And again, I'll just reiterate for anyone who missed it. Think about it too, right, guys? Like cold cases. Imagine you've got like a heinous, atrocious crime, right? That happened. Let's say it was someone who was young and where, for example, the defendant is still alive. And, you could even say Golden State Killer is kind of an example, right? They get caught, but it's like 50 years later, right? And then let's just say that the victim doesn't have any family still alive, right? Or it could even be remains that are never identified. Or you could have people that just don't have that many family members, or the family members don't want to make a victim impact statement. And think about that, right? Because if to the extent that anyone thinks that should be that the victim impact evidence does persuade a jury and is a part of their sentencing decision in a capital case, how is that fair then to people who don't have family members left, right? So that's another thought. Okay. The admissibility of victim impact evidence violates the Eighth Amendment in Florida's prohibition against non-statutory aggravating factors. Right. Victim impact evidence is not an aggravating factor. Yep, we covered that. In a weighing state like Florida, there is an Eighth Amendment error when the sentencing jury weighs an invalid aggravating circumstance in reaching the ultimate decision to impose a death sentence. Employing an invalid aggravating factor in the weighing process creates the possibility of randomness. By placing a thumb on death side of the scale, discriminate. And again, even the discrimination in terms of just like it being unfair, again, it's really not just for the defendant. Because again, if you look at a victim who just doesn't have anybody who can come speak on their behalf, how is that fair to them if you're for the death penalty, right? Even. The powerful empirical evidence demonstrates that jurors will treat victim impact evidence like an aggravating factor despite any instructions to not do so. So in other words, this cannot be cured by a jury instruction. That's what that's saying. And use it to impose a death sentence. And it's a violation of the Florida law and the Eighth Amendment. Victim impact evidence violates the Florida evidence code. So this is probably an argument similar. We saw something like this with BK, where they were saying, again, about, I guess the way they were handling it was that all that the evidence needed to be proven beyond a reasonable doubt, even if it was non-statutory, which, that argument didn't go very far because the rules of evidence, another thing, the rules of evidence don't apply during sentencing, right? During the sentencing phase, the rules of evidence don't apply. I mean, I just, yeah. Oh my God, Glenn. Oh, Glenn. Glenn was our troll from the Adelson case. That was such a funny thing. Who knows? Glenn apparently is probably busy writing his book about Wendy Adelson. So be on the lookout for that new #1 New York Times bestseller, guys. And the other thing too, well, I've talked about this a little bit before, but I don't understand their charging decisions in this case too, right? With Mario. Again, if you compare it, to the Adelsons, right? Where you've got, co-conspirators and you've got solicitation, right? For example, Mario, from everything we know so far, right, was like a Katie Magbanua. He was like the middle person, right? I just don't understand. I don't understand the charging decisions at all. And it is interesting, as we've talked about before too, that they've not filed a motion for severance, that they're still being tried jointly. Like, so that to me, again, if we're trying to look into the future, right? Like, as far as like strategies or whatever, it looks like it's not going to be throwing each other. And it's really funny. I heard, where was it? So just recently, right? There was somebody talking about how they were going to throw each other under the bus. I can't remember where that was, but I was like, oh my God, what are people talking about? Because like, while that is a normal, like normally that's what you would have in cases, those are cases where the defendants are being tried separately. And the fact that they're being tried jointly means that was not going to work, right? That they haven't even filed those motions. It's not like they filed the motions and those were denied. So now they have to go with what they've got. They haven't filed those motions. This means, and we've seen it, their defensive teams are working together. And I think it's because they're like, the evidence is equally lacking for both of them. And they're better off with working as a team, right? It's going to be really interesting to see how all this plays out. They're bifurcated. You're talking about the guilt phase and the sentencing phase? I've been sort of switching topics, so I might have confused somebody. They will be split. You mean, are you talking about Shanna and Mario being tried separately? Like, because I have not seen that. They are still they're co-defendants. They're being tried jointly. Now for the sentencing phase, they will be separate, if that's what you mean. But for the trial, they're being tried jointly, versus, separate trials. With their powers combined, they will vanquish the state. We'll see. We'll see what happens. So, okay, so victim impact evidence violates the Florida Evidence Code. The Florida statute states relevant evidence is inadmissible if its probative value is substantially, 403, right? Like I said just a few minutes ago, probative versus prejudicial, right? And then you've also got cumulative. Therefore, victim impact evidence should be excluded because, as the recent empirical studies clearly demonstrate, any probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, and misleading the jury. What trial was it that I was talking about recently? Now I'm having a flashback. There was a trial I was talking about recently where it was co-defendants. And, I know what it was. Duh. It was with the Adelsons. It was with Katie McBanoa and Sigfredo Garcia. That was an example of where they were tried jointly, but received different sentences. Or sorry, no, that's not what it was. Sorry, hold on. Let me back up. They were tried jointly, but the jury found Sigfredo Garcia guilty, and the jury was hung on Katie McBanoa, and that's why she got a retrial. Yeah. Oh, things that hasn't come out. Oh my God, do share, please. Let us know. We want the scuttlebutt. Feel free to share the knowledge. So you're saying they are going to be interesting. Huh. Yeah. Like I said, I checked the docket this morning. And so, but does excited utterance, do you have a squirrely crystal ball? Do you have a squirrely crystal ball? So magical. Okay. True. First, victim impact evidence has very little probative value. Yeah, for the purpose of executing Florida's capital sentencing scheme. The jury is instructed to weigh only the aggravating factors in mitigating circumstances. There's no probative value. Yep. Unfair prejudice. Wherefore? For the following reasons. Okay, so it looks like now we've got some exhibitees. There's Mr. Carodi. So here's the exhibitees. Now, at some point they will have a hearing and argue all this. So we're not going to read all this. But there's the exhibitees. So on to the next one. Special victim impact instructions. Now, this would be Plan B, right? Because as they stated in their first motion, the studies show that the juries, well, I'm assuming that this is going to be something like a jury instruction, right? But the studies show that the jurors don't pay attention to that when it comes to this. So, yes, there it is. Yep. Jury instruction. So, again, as Plan B, if indeed it's not excluded, right? So Plan A, please exclude it. Well, okay, let me back up. Plan A, strike the death penalty altogether, right? And then there were other motions we already covered. But once you go through all those, then we get to this. Then it's like let's say this is Plan E, okay? Plan E, exclude the victim impact evidence, right? And then Plan like F would be give them a special jury instruction. So, Right. I mean, all that makes sense logically that it would be a good strategy for her. But the only reason I'm saying that I would assume that's not happening is just because, again, there's not been a motion to sever. So that's what I'm wondering, if you have any knowledge that that is in the works. But I mean, for anyone who hasn't seen this, you know, I've been covering the Casey Anthony trial gavel to gavel. We actually had the most recent episode yesterday. We are on day 23 of the trial, and I'm the first person on YouTube to cover it. And so, no, if you're looking for a fan of Jose Baez, look no further. He is at this point my favorite defense attorney, and that's saying a lot because I have a lot of favorites. He is far and away my favorite defense attorney, and actually that's why I started covering this, right? Because Flash, thank you, Flash, reminded me during the Casey Anthony coverage that Jose Baez was her defense attorney, and that was all. I was like, enough said, done. Let's add that to the list of things I'm covering, because I was like, all right, now we're gonna get caught up, because yeah. So he's amazing. Okay, so defendant's motion for special victim impact instructions. So this would be their suggestion. You have heard statements about the impact of this homicide on the family, friends, community of the decedent. This information was provided to you to satisfy the court's obligation under Florida law to permit those impacted by the crime to speak in an open court regarding the victim's uniqueness as a right. Like here, this is great. Let me just reiterate. Under Florida law, right? And this is the way it should be. Victims should be permitted, those who are impacted, right, to speak in open court regarding the victim's uniqueness as an individual human being and the loss to the community by the victim's death. Again, they can do that after the sentence is rendered. Just my one humble squirrel's suggestion. However, the law does not permit you to use this information as an aggravating factor, and therefore it should play no role whatsoever in the weighing process you must engage in to determine an appropriate sentence in this case. So yeah, that's about it for this one. So now this would be plan G, right? If we go with that example, defendant's motion to limit the amount of victim impact information. So we've got, first we had excluding, then we had special jury instruction, now we got limiting it. And again, here we go, right? Right here. Does this seem unfair to the victims? Yes. Limiting what they can say? Yeah, absolutely. This is what we've just been talking about. But again, this would not be happening if it was after the sentence. So, so the law is the same, but here we go. Neither the Florida Supreme Court nor the U.S. Supreme Court have established a bright line rule as to the number of victim impact statements or photographs that are or are not admissible by the state during a capital sentencing phase. And this law is sort of the same about number of photographs. Okay, so they're saying like, okay, given the way Jared Bridegan has been portrayed in the media and on social media, and the number of supporters that have attended court hearings to date, the defendant's counsel are concerned that the state will seek to present an excessive victim impact case during any penalty phase that will be so unduly prejudicial that it violates Ms. Gardner's due process. Wherefore, limit it. Limit it. Okay. Next, we have EF. G, wait, are we on H, letter H? Defendant's motion for victim impacts to be heard at Spencer hearing. Okay, interesting. This has got to be Florida specific, Spencer hearing. Okay, cool. We're going to learn something new here. My guess is this would be a preview, right? A Spencer hearing would be they preview it, sort of like a proffer. Hear any victim impact evidence presented by the state during the Spencer hearing, if any, and to prohibit its presentation before the jury. So this is all the same. So I'm wondering if it's going to go into more about the Spencer hearing specifically, though. Inflammatory, I mean, a lot of this is the same. Wherefore, the defendant moves to honorable court to hear any and all victim impacts evidence only at the Spencer hearing, should one be necessary. Interesting. Let me pull something up here. Hold on. Give me just a second here. We're going to pull up some case law. Yay! We love case law. All right. Let me unshare, reshare real quick. Flash is asking a question. Who's Spencer? We're going to learn. So excited utterance agreeing he's the best. Jose Baez, yeah. So did somebody cover some of the Casey Anthony trial? I haven't seen. I mean, I have not seen that. If anybody has covered it, but yeah. Yeah, I loved Rosemary. She argued in a recent motion, and I thought she did a phenomenal job. Okay, so here we go. Who's Spencer? Spencer v. State. So this is from the Florida Supreme Court. All right. So following the jury's recommendation, the trial court sentenced Spencer to death for first-degree murder. On appeal, we affirmed the convictions, but vacated the death sentence because the trial court improperly found, there it is. Remember, we just talked about this, the CCP, right? Aggravator, cold, calculated, premeditated. The trial court improperly found the CCP aggravating circumstance and improperly rejected the statutory mitigating circumstances. Consequently, they've remanded it for reconsideration. After hearing argument from the parties, the judge again imposed the death sentence. So this was an example. We talked about this on I think on the death penalty motions part 1, where we learned that the history of when it used to be decided by a judge and then got decided by a jury. So it looks like this was from back when the judge made the decision, not the jury. And we also talked about that case where the jury found no for the death penalty, and the judge overruled them and was like, no, I'm giving him death. And then that was overturned. We talked about that too. And then they put a law that you couldn't do that. So the judge found 2 aggravating circumstances. He was previously convicted of a violent felony, and the there we go. There's the good old hack aggravator, guys. The judge also found 3 mitigating circumstances. In weighing the aggravating and mitigating circumstances, the judge gave some weight to the. So on appeal to this court, Spencer raises 2 issues, the first of which includes a number of sub-issues. In the first issue, Spencer argues that the death sentence was improperly imposed. And there was a hearsay issue. They found no error. Let me just see here. Or gets to the hearing. Let me just see here. And then accordingly, we affirm the imposition of the death sentence. It is so ordered. So I wonder, and then there's a dissenting opinion. Interesting. So I wonder, let me see. Because there was also, let's see. My guess is they had to have a hearing to come to that conclusion. So let me look at this one here. Interesting. We had a co-defendant. Hung jury initially. Wow. And then there was a third trial. They found Spencer guilty. Okay, here we go. After the conclusion of the trial and the penalty phase proceedings before the jury, Spencer filed a motion for a new trial. A single hearing date, this is it. This is the hearing. A single hearing date was then scheduled for that motion and the sentencing proceeding before Judge Carlisle. When the scheduled time for the hearing to begin had passed and neither Judge Carlisle nor the state attorney had appeared in the courtroom, defense counsel entered the judge's chambers. Defense counsel found Judge Carlisle, the state attorney, and state attorney's assistant proofreading an order sentencing Spencer to death. What? When the court convened moments later, defense counsel noted for the record the situation he had encountered and asked the judge to address it. What? Oh my God. This is crazy. Defense counsel voiced his concern. Yeah, no kidding. And then they moved to recuse Judge Carlisle. The judge denied the motion, as judges do. Wow. Several days later, defense counsel filed a second and formal motion for the recusal of Judge Carlisle. Defense counsel also filed a motion calling for Judge Carlisle to withdraw his ruling on the motion for a trial. Wow. And then, so finally, Judge Carlisle did grant the motion to recuse himself or herself. After Judge Carlisle recused himself, a substitute judge was assigned. The substitute judge then imposed the death sentence, finding the aggravating factors. Okay. Ex parte communications. Wow, there's a lot going on here. So I have to wonder if the Spencer hearing is when there's a motion for a new trial on the table in between the two phases, right? After the guilt phase and before the sentencing phase. Let me see. Okay, yeah, okay. Right. It's an opportunity for the defendant's lawyers to present additional evidence to the judge before sentence is entered. Okay. Right. So they can either argue that there's more mitigating factors. Okay. Okay. So, let's go back to where we were. Unshare, reshare. Oh my gosh. I didn't mean to do, okay. Hold on. Okay. Oh, did Excited Utterance do a stream on Casey Anthony? Really? That is, awesome if that's the case. But yeah, as far as gavel to gavel, you know, I have not seen anybody do it. Okay, so now we have next up, defendant's motion to prohibit all use of the word recommendation to describe the jury's role in the penalty phase. So you know what this is? You know what this is? This is just like why in Idaho, we've talked about this before, in Idaho, they don't recommend the death penalty. Instead, they're told that they have to see if there's any reason why not imposing it would be unjust. It's like it's like a double negative situation. It's like that they don't recommend the death penalty. It's like they're supposed to be looking for reasons that it would be unjust to impose it, basically. So, so that's what this is. This is along those lines, right? Because Florida is still using, recommend the death penalty. So this would include, for example, the use of the word by the parties during voir dire, in instructions and in opening closing statements. The newly amended sentencing statute and instructions promulgated by the Criminal Jury Instructions Committee of the Florida Bar repeatedly state that the jury's role is to issue a recommendation for a death sentence and provide that the trial judge has discretion even after the jury's final recommendation as to the final sentence. Now, remember, their discretion would only be to say, they can only overrule it for life. They can't overrule it for death because that happened one time and then they made a law against it, as they should. The statute uses the term recommendation 7 different times. Wow. While the predecessor version of the statute also used recommendation several times, it is different in the newly amended statute, which requires only 8 votes for a death sentence. Okay, let's take a look at this. So on March 5th, 2020, the Florida Supreme Court announced that it would no longer review and authorize jury instructions. Instead, jury instructions after that date are published by committees. Okay, there we go. So moreover, the prior jury instructions, which were ratified by the Florida Supreme Court, did not use the term recommendation and instead used the terms verdict and decision. In fact, those jury instructions specifically struck the word recommendation, which had been used extensively previously. The repeated use of the word recommendation by the court in instructions by the state misleads jurors in a way that diminishes their sense of responsibility. Oh, interesting. Each juror must understand that he or she alone is responsible for his or her sentencing decision and cannot rely on someone else to review or correct. I see. So what they're saying is that by recommending it, it makes it could be misleading to say that it's not really that you don't bear the, how to say this, the burden or the responsibility of that, right? Like that it could always be undone, which, I mean, it can be, like the judge again can overrule it, right? But like that is not, that the point isn't to tell the jurors, hey, just so you know, the judge can overrule it, right? Like just so it's not, you don't have to really worry about it, right? They need to think that they should think that it's final, right? And understand that he or she alone is responsible. Yeah. Uncorrected beliefs that responsibility for any ultimate determination of death will rest with others creates a bias towards death sentence. Right. In other words, they could use it to send a message, even if it's not the appropriate punishment. A jury led to believe a life sentence cannot be increased to death, which is in fact the state of current Florida law, like I just mentioned, may vote for a death sentence because it understands that delegating responsibility for the sentence can only be effectuated by returning a death sentence. It is essential that jurors recognize the truly awesome responsibility, awesome in a bad way, right, of decreeing death for a fellow human, will act so that they will act with due regard for the consequences of their decision. For obvious reasons, jurors might view judges as more experienced and better equipped to make the life or death sentencing decision. Yeah, using the term recommendation invites jurors to pass the buck to the learned judge. Leaving jurors with the impression that they only make a recommendation provides the way out for jurors to avoid, again, the awesome, in a bad way, responsibility for a decision to sentence a fellow human being to death. Okay, and next. Defendant's motion for presumption of life penalty phase instruction. Interesting. Presumption of life. Okay. Interesting. Okay. The law presumes that a defendant who's been convicted of first-degree murder is entitled to a life sentence without the possibility of parole. Because in Florida, it's just life is life, right? Specifically, Ms. Gardner requests the following instruction be read during both the preliminary and final penalty phase, if any instructions. The instruction is modeled on standard instructions 2.1, blah, blah. And here's the instruction. In support of this motion, Ms. Gardner would show 1, Ms. Gardner is charged by indictment with first-degree murder, and the state of Florida has given its notice for the death penalty. The default punishment of first-degree murder under the laws of Florida is a life sentence without the there it is. The default punishment right there for first-degree murder under Florida law is a life sentence without possibility of parole. That's the default, right? Procedurally, the state can only seek a sentence of death if it files a specific notice. Well, yeah, they've already done all that. Aggravating factors, we've been there. Right, they have to prove it. We've talked about this beyond a reasonable doubt. Without the statutory scheme resulting a jury recommendation for a death sentence, by default, the defendant is sentenced to life in prison without the possibility of parole. Life is the most basic of rights. 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 Li It would be absurd to believe that the United States Constitution requires a jury to be instructed on the presumption of innocence, right, during a guilt phase, but not the presumption of life during a capital penalty. Let me read that again. It would be absurd to believe that the United States Constitution requires a jury to be instructed on the presumption of innocence during a guilt phase, but not the presumption of life during a capital penalty phase, given the explicit constitutional language protecting a citizen's life. And that's basically that for this one. Mr. Carodi again. Yeah, I know that would be Flash. Go ahead and eat your ice cream. Of course. Go have your ice cream. So let me see here. Let me see how many more motions we've got left here. So the next batch of death penalty motions is dealing with the law, basically here. Can you guys see this? Yes. Okay. Because of the most recent amendments in 2023. This is a whole other thing. This is what I was referencing here, right, where they changed the law to eight votes instead of 10. So look at this, right? So April 20th, 2023, which by the way was right before the Y&W Melly trial. Governor DeSantis signed it into law. Except, oh, interesting. Okay. So this Florida statute here, effective reenactment or amendment of criminal statutes, referencing criminal statutes, it provides in pertinent part. Except as expressly provided in an act of the legislature, the reenactment or amendment of a criminal statute operates prospectively and does not affect any of the or abate any of the following: the prior operation of the statute or prosecution or enforcement thereunder, a violation of the statute based on any act or omission occurring before the effective date. So, right. So anybody who was, prior to that date, they still get 10 out of 12 versus 8. Thus, the legislature's amendments operate prospectively to acts or omissions occurring after the effective date. Oh. What they're saying here is that because the acts happened before this, right? 2022 of the alleged murder. Interesting. They might have a point here, or they might, of course they have a point, but they might get somewhere with this, right? Because interesting. Okay. Wow. Okay. Yeah. So, So in other words, this is the date, the last amendment that they would be working with, which is like the 10 out of 12. It's not there's no retroactive application. Interesting. Yeah, this interpretation is consistent with legislative intent because the effective date language in the statute and the lack of retroactivity language in the statute makes it clear and obvious that the intent was not to apply the amendments retroactively to pending capital cases. Right. Okay. And now they're saying, is it clear or is it unambiguous? No, so it was very clear. So to the extent this court believes language is susceptible of different constructions, the law provides criminals shall be construed most favorably to the defendant. So that is interesting. So guys, we will cover the rest of these on the next one. Hopefully there will be some more news as well as to like when the next hearing is, or maybe we will see something about them being a motion to sever. That would be interesting as well. So yeah, don't worry. I'm reading it to you. Well, at least things that, some of it's a bit repetitive, but things that aren't repetitive. But y'all, hopefully you guys can join us tomorrow for the BK stream, because I'm really looking forward to that. And I am just thanks everybody for being here. Thanks y'all for being a squirrel, and hopefully see you guys soon. And love you guys, and squirrel out.